Stay in the vehicle and calm down.
I am calm. You are escalating this unnecessarily. I haven't done anything wrong.
Officer Scott Pemberton had been with the Austin Police Department for 14 years. And in those 14 years, he'd compiled a record that should have raised immediate concerns. 2023 complaints, 19 of them involving African American citizens. A black cardiologist in Westlake Hills, accused of driving a stolen vehicle, his own Mercedes registered in his name. An African American attorney in Tarrytown, questioned about loitering outside her own law office. A black engineering professor in Hyde Park, detained for suspicious behavior, jogging in athletic wear at 6 a.m. Each one involved an African American professional in a predominantly white area. Each one followed the same script. Pemberton couldn't believe black people belonged in Austin's affluent neighborhoods, couldn't accept they owned the homes, the cars, the businesses. Each complaint ended identically. Implicit bias training that Pemberton attended but never applied. Cultural sensitivity workshops that never changed how he saw black skin as reasonable suspicion. One Thursday evening in Austin, his 14 years of racial profiling collided with someone Pemberton never expected. An African American woman with a lifetime appointment to the federal bench. Someone who knew the law better than Pemberton ever would, knew her rights, and knew exactly what Pemberton was doing. And that collision would finally end Pemberton's career, cost the city $1.8 million, and expose a department that had tolerated his pattern of racial profiling for nearly a decade and a half. An African American woman in her late 40s, Judge Simone Harrington, was driving east on West 6th Street in downtown Austin. Judge Harrington wasn't just anyone. She was a United States District Court judge for the Western District of Texas, appointed by the President and confirmed by the Senate. Before that, she'd been a federal prosecutor for 12 years, a partner at one of Austin's most prestigious firms, and had graduated summa cum laude from Yale Law School. She was driving home from the federal courthouse, still in her judicial robes covered by a blazer, briefcase on the passenger seat, containing case files she'd reviewed that evening. Her vehicle, a charcoal gray Lexus ES, was registered in her name, insurance current, inspection sticker valid. She'd signaled every turn, stayed 5 miles under the speed limit, stopped completely at every sign. No crime, no traffic violation, no equipment failure, just a federal judge driving home from work. But Officer Pemberton saw her through a lens warped by 14 years of unchecked racial bias. Couldn't process that an African American woman in a luxury sedan in downtown Austin could be a federal judge. Couldn't imagine that the black woman he was about to pull over had the authority to sentence people to federal prison, rule on constitutional questions, and knew his Fourth Amendment obligations better than his training officers. Before we continue, where are you watching from? If this is your first time here, please hit that subscribe button. Stories like these need to be shared, and your support helps us bring more truth to light. Austin, Texas, the state capital, known for its tech industry, live music, and rapid gentrification that had pushed longtime black and Hispanic residents out of central neighborhoods. Downtown Austin, where the federal courthouse sat among high-rise condos, upscale restaurants, and corporate offices. This was the Austin that tech money built. Median condo prices exceeding $600,000, trendy cocktail bars, and a demographic that was 74% white. The kind of place where seeing a black woman behind the wheel of a luxury car raised suspicions in officers like Pemberton. The kind of place where African Americans were assumed to be Uber drivers, service workers, or, in Pemberton's worldview, people who didn't belong. West 6th Street featured boutique shops, craft breweries, and restaurants where entrees started at $40. The clientele was overwhelmingly white, affluent, young professionals who could afford Austin's skyrocketing cost of living. It was 6:45 p.m. on a Thursday evening in October. Clear skies, temperature in the low 70s, that perfect Texas autumn weather. Rush hour traffic was thinning, the sun setting over the hill country to the west, casting downtown in golden light. Judge Simone Harrington had been on the federal bench for 6 years. 6 years of presiding over criminal trials, civil disputes, constitutional questions, 6 years of sentencing drug traffickers, resolving complex litigation, protecting civil liberties. She'd graduated from Spelman College, then Yale Law School, where she'd been an editor of the Yale Law Journal. She'd clerked for a Fifth Circuit judge, prosecuted white-collar criminals, and public corruption cases as an assistant U.S. attorney, then joined private practice where she'd argued before the Fifth Circuit Court of Appeals multiple times. Her colleagues called her brilliant. Her former law partners called her principled. Even defense attorneys who lost cases before her called her fair. She believed in the rule of law. She believed in equal justice. She believed that the Constitution protected everyone, regardless of race, wealth, or status. But she also knew from both professional experience and personal reality that being black in America meant constantly proving you belonged, that judicial robes didn't stop racist cops from seeing the color before the credentials, that every professional success came with racial presumptions she had to overcome. That Thursday evening, Simone had finished a sentencing hearing that ran late. Nothing unusual, nothing exciting, just what she did every week. A federal drug case, defendant sentenced to 87 months, paperwork completed, orders signed. She'd changed from her judicial robes into a blazer over the blouse and skirt she'd worn underneath, gathered her briefcase with case files she needed to review, and walked to the courthouse parking garage. She'd driven out onto West 6th Street, headed toward her home in Hyde Park, a historic neighborhood north of campus where she'd lived for 8 years. Her Lexus was a 2022 model. Nice, but not ostentatious. Registered in her name, purchased with her salary as a federal judge. Completely legitimate. She belonged in Austin. She worked downtown. She owned property in one of Austin's most desirable neighborhoods. She was doing exactly what thousands of professionals do every single day. Commuting home from work, thinking about dinner, planning to review case files that evening before an early morning court session. Nothing suspicious, nothing unusual, nothing that should attract police attention. Nothing that would make anyone look twice at a white person doing the exact same thing. But Officer Pemberton, 14 years on the Austin PD with 23 complaints documenting his pattern of targeting black citizens in affluent areas, saw something different. Pemberton had been with Austin PD since his early 20s, hired in 2010 straight out of the police academy. He'd worked patrol in various districts over the years, but spent the last 7 years assigned to downtown and West Austin, the affluent, predominantly white areas where tech executives, university administrators, and state government officials lived and worked. His supervisors kept him in these assignments despite his complaint history, because, in their words, he's proactive, knows the area, keeps crime stats down. What they meant was that Pemberton stopped every black person he saw in white spaces, questioned African Americans about their presence, made white residents feel protected from black people they assumed didn't belong. 23 complaints in 14 years, 19 of them involving African American citizens. The pattern was unmistakable. 2015, a black teacher driving through Tarrytown. Pemberton pulled her over for suspicious behavior. She was actually returning from parent-teacher conferences at the elementary school where she taught. Pemberton demanded proof the vehicle wasn't stolen, despite valid registration and her name on the title. Complaint filed. Closed with implicit bias training. 2018, an African American business owner walking near his restaurant in West Austin. Pemberton stopped him, demanding ID and explanation for his presence. The man owned the upscale steakhouse across the street, was checking on a delivery. Complaint filed. Resolved with a written counseling and cultural awareness workshop recommendation. 2021, a black psychiatrist sitting in her parked car outside a medical building in Westlake Hills, reviewing patient notes between appointments. Pemberton approached with hand-on weapon, demanded she exit the vehicle, wouldn't accept her explanation or medical credentials. She worked in the building, had been seeing patients there for 8 years. Complaint filed, dismissed with diversity seminar requirement. Every complaint told the same story. Pemberton saw African Americans in white spaces and couldn't accept their legitimacy, couldn't accept that they belonged. He assumed stolen vehicles before checking registration, assumed trespassing before asking, assumed criminal intent before criminal activity. He demanded proof of belonging, proof of ownership, proof of legitimate presence. Things he never demanded from white people in the same locations doing the same things. And when complaints were filed, the department responded with training certificates instead of discipline, with workshops instead of consequences, with one more chance instead of termination. Internal Affairs had a file on Pemberton that should have resulted in termination years ago. 23 documented incidents, 4 settlements paid totaling $215,000, 17 credible witnesses, 8 sustained complaints. But Pemberton had allies in the department, supervisors who valued his arrest numbers and proactive approach to policing, union representatives who protected him at every disciplinary hearing, and a system that prioritized officer retention over accountability to the black citizens he repeatedly profiled. That evening, Pemberton was on patrol downtown when he noticed the Lexus driven by a black woman. No traffic violation, no equipment issues, no call for service, just his biased perception. He ran the license plate, came back registered to Simone Harrington at a Hyde Park address. Clean record, no warrants, current registration, everything legitimate. But Pemberton's mind made the calculation it always made. Black woman plus luxury car equals doesn't add up. Must be borrowed, must be stolen, must be someone's employee, must be something wrong. He didn't consider this could be a judge, an attorney, a doctor, a CEO. He didn't notice the federal courthouse parking permit on the windshield. He didn't observe that the driver was calmly proceeding home, obeying every traffic law. He saw what his biases trained him to see: a black person in a car too nice for them to own, a situation that needed investigation, reasonable suspicion manufactured from skin color. Pemberton activated his lights. Simone saw the flash of red and blue in her rearview mirror, and her stomach tightened. She'd lived this before, not as a judge, but as a black woman in America. She'd seen colleagues experience this, heard the stories from defendants in her courtroom, studied the statistics on racial profiling in her law school classes decades ago. Here we go again. Another white cop who can't believe I belong. She signaled, pulled to the curb on West 6th near Lamar, put the car in park, hands visible on the steering wheel at 10 and 2. Every movement deliberate, every action designed to give no pretext for escalation. Pemberton approached the driver's side, hand resting on his service weapon, flashlight aimed at her face despite plenty of ambient light. License and registration, he demanded. No greeting, no explanation for the stop. Simone kept her hands visible. Officer, may I ask why you stopped me? I wasn't speeding. I signaled all my turns. I stopped at license and registration. Now. She reached slowly for her purse, narrating every movement. I'm reaching into my purse on the passenger seat for my wallet. She produced her Texas driver's license, clearly showing her name, address, photograph. She retrieved the registration from the glove compartment, showing the vehicle was registered to Simone M. Harrington at her Hyde Park address. Pemberton examined them under his flashlight, frowning. This your car? Yes, officer. As you can see from the registration, whose car is it really? You borrow it? You drive for someone? Simone's jaw tightened. She knew exactly what he was implying. Officer, I just provided you with registration showing this vehicle is titled and registered in my name. It's my car. I purchased it. I own it. Do you think departments should track officers with multiple similar complaints? Drop your answer below. Where are you coming from? Work. What kind of work? I'm an attorney. She didn't say judge yet. Wanted to see how far this would go, how deep his assumptions ran. Uh-huh. What firm? I work at the federal courthouse. Pemberton's expression didn't change. As what? Secretary? Paralegal? There it was. The assumption that a black woman couldn't be an attorney at the federal courthouse had to be support staff. Simone took a slow breath. Officer Pemberton, she read his name tag. I'm going to reach into my briefcase for my credentials. Slowly. She retrieved her federal ID badge, the one that got her through courthouse security, the one with her photograph and title clearly visible. The Honorable Simone M. Harrington, United States District Judge, Western District of Texas. She held it up for Pemberton to see. He stared at it, his face going from suspicion to confusion to something like anger. This could be fake. It's not fake. Call the courthouse. Call the U.S. Marshals. Check your own department's database. Federal judges are flagged. Anyone can make an ID. Officer, you pulled me over without reasonable suspicion or probable cause. I violated no traffic laws. You stopped me because you saw a black woman in a nice car and assumed I didn't belong. That's racial profiling, and it's a Fourth Amendment violation. I'm a federal judge. I know the law. I know my rights, and I know exactly what you're doing. Pemberton's hand moved back to his weapon. Ma'am, I need you to step out of the vehicle. On what grounds? What's your reasonable, articulable suspicion of criminal activity? Ma'am, step out of the vehicle now. I'm not getting out. You have no legal basis for that order. You pulled me over without cause. You verified my identity and vehicle registration. And you're now escalating because you can't accept that a black woman is a federal judge. I can have you removed from that vehicle. And I can have you in federal court for civil rights violations. I suggest you call your supervisor right now. Pemberton stepped back to his patrol car, his hand shaking slightly as he keyed his radio. Central, 4 Adam 22. Need a supervisor at my location, West 6th and Lamar. Within 4 minutes, a supervisor's vehicle arrived. Sergeant Maria Rodriguez, a 16-year veteran who'd tried to discipline Pemberton twice before and been overruled by command staff. She approached Pemberton first. What's the situation? Traffic stop. Driver's being uncooperative, claims to be a federal judge. ID might be fake. Rodriguez walked to Simone's window. Simone handed her the federal credentials. Rodriguez examined them carefully, then pulled out her phone and made a call. Simone could hear her speaking to someone, verifying the badge number, confirming the judicial assignment. Rodriguez walked back to her vehicle, made another call, this one to the U.S. Marshals Service, which provides security for federal judges. 3 minutes later, she returned to Pemberton, her expression grim. The ID is legitimate. Judge Harrington is on the federal bench, Western District, assigned to the Austin courthouse. The marshals confirmed it. What was your probable cause for this stop? Pemberton hesitated. The vehicle looked suspicious. Looked suspicious how? Was she speeding? No. Running lights. Expired tags. Equipment violation. No, but what, Pemberton? What was your reasonable suspicion? Silence. You pulled over a federal judge with no legal basis. You accused her of lying about her identity. You threatened to physically remove her from her vehicle. Do you understand what you've just done? A white man in a business suit approached from the sidewalk where he'd been watching. Sergeant, I saw this whole thing. She was driving normally, obeying all traffic laws. Your officer pulled her over for no reason, then refused to accept her credentials. I'm an attorney, and that was textbook racial profiling. A black woman came forward from a nearby bus stop. I recorded part of this on my phone. The judge was completely calm and professional. Your officer was aggressive from the start. Rodriguez turned back to Simone's vehicle. Judge Harrington, on behalf of Austin PD, I apologize. This stop should never have happened. Simone stepped out of her vehicle now, her full professional authority visible, the bearing of someone used to commanding courtrooms, the confidence of someone who knows the law better than most police officers ever will. Sergeant Rodriguez, I'm Simone Harrington, United States District Judge. I've been on the federal bench for 6 years. Before that, I was a federal prosecutor for 12 years, where I worked with your department on numerous cases. I know proper police procedure. I know what reasonable suspicion requires, and Officer Pemberton had none. She gestured toward her vehicle. I violated no traffic laws. My vehicle is properly registered in my name. I'm driving home from work, from the federal courthouse where I heard cases today. Officer Pemberton stopped me because he saw a black woman in a luxury car and assumed I didn't belong. That's racial profiling. Rodriguez nodded. I understand, Your Honor. I'm calling command staff now. Within 12 minutes, Captain Jennifer Morrison arrived. A 22-year veteran who'd been reviewing Pemberton's file for years, had written memos warning about his pattern, and had been overruled by Union protections and command staff reluctance to terminate officers. She examined the scene, a federal judge, multiple witnesses, body cameras running, a stop with zero legal justification, She spoke with Rodriguez, reviewed Pemberton's documentation. There was none. No traffic violation, no reasonable suspicion articulated. Confirmed Judge Harrington's identity with the marshals again, and verified the witness accounts. Then she turned to Pemberton with an expression of finality. Badge and weapon. Now. Pemberton's face went white. Captain, you just racially profiled a federal judge in front of witnesses and cameras. Badge and weapon. You're on administrative leave effective immediately. But let's be clear, your career is over. Pemberton's hands shook as he handed them over. The weight of 14 years of complaints, 23 incidents, mean black victims, catching up in a single moment. Morrison turned to Judge Harrington. Your Honor, on behalf of Austin PD, I apologize. This was completely inappropriate. This was racial profiling. This was a violation of your rights. Officer Pemberton will face immediate termination proceedings. If you choose to file a complaint or pursue legal action, and you should, the department will cooperate fully. This pattern should have ended years ago. Simone looked at Pemberton, then at Morrison, taking a moment to gather her thoughts. Captain, I've been a federal judge for 6 years. Before that, I prosecuted federal cases, including civil rights violations. I've presided over cases involving police misconduct, excessive force, unlawful searches. I know what Fourth Amendment violations look like. I teach constitutional law as an adjunct professor at UT Law School. She gestured toward Pemberton. And your officer just committed textbook racial profiling right in front of witnesses and cameras. No traffic violation. No reasonable suspicion. No probable cause. Just a black woman in a nice car. And he assumed criminal activity. She gestured toward the body cameras, the witnesses with phones. Everything is documented. The lack of legal justification, the racial profiling, the assumption that my credentials were fake, all of it. So yes, I'll be filing a complaint. And yes, I'll be pursuing legal action, not primarily for compensation, but because if this happens to me, a federal judge with a lifetime tenure, institutional support, and comprehensive legal knowledge, imagine what happens to people who don't have my resources, my understanding of the law, my ability to fight back. She paused, letting the weight of that reality settle. How many young black women has Officer Pemberton stopped who couldn't challenge him? How many African Americans did he profile who didn't have witnesses or cameras? How many complaints would it have taken before someone acted? By that evening, the story was spreading through Austin's legal community and onto local news. Witness video clips went viral. #judge profiled and #driving. While black started trending in Texas, the headlines captured the absurdity and outrage. Federal judge racially profiled during traffic stop by Austin police officer. APD officer with 23 complaints caught on camera profiling U.S. District Judge. Federal judge detained for driving while black by Austin officer. The legal community responded immediately and forcefully. The Western District Bar Association issued a statement supporting Judge Harrington, calling the incident completely unacceptable and a clear example of racial profiling that undermines public trust in law enforcement. The Travis County Black Lawyers Association condemned the incident, demanding Pemberton's immediate termination and systematic reforms. Even the Austin Police Association, the union, remained notably silent, unable to defend the indefensible when the victim was a federal judge with perfect documentation and multiple witnesses. The federal courthouse received hundreds of calls and emails supporting Judge Harrington, along with demands that APD face comprehensive accountability. Judge Harrington hired Marcus Blackwell, a prominent civil rights attorney who'd won multiple high-profile cases against Texas police departments. The lawsuit was filed 3 weeks later, naming Officer Scott Pemberton, his supervisors who'd ignored 23 complaints over 14 years, the watch commander who kept him on patrol in affluent areas despite the documented pattern, and Austin Police Department. The allegations were comprehensive and damning. Racial profiling in violation of the Equal Protection Clause of the 14th Amendment. Unlawful detention without reasonable suspicion or probable cause in violation of the Fourth Amendment denial of civil rights. Under 42 U.S.C. Sefer 1983, intentional infliction of emotional distress. false imprisonment, supervisory liability for failure to train, discipline, or terminate. Despite documented pattern, municipal liability for deliberate indifference to Officer Pemberton's pattern of racial profiling. Violation of Texas civil rights statutes. The complaint included Pemberton's entire history, presented in devastating detail. 23 complaints over 14 years, 19 involving African American citizens in similar circumstances, affluent areas, professional settings, white neighborhoods, all documented, all investigated, all resulting in minimal discipline, all dismissed with training that never changed his behavior. The lawsuit laid out the pattern systematically, complaint after complaint, year after year. Black victim after black victim, similar circumstances, similar assumptions, similar harassment, and the department kept Pemberton on patrol. Damages sought, $1.8 million, plus attorney fees and mandated policy reforms. Austin city attorneys reviewed the case. The evidence was overwhelming. Security footage from businesses along West 6th showed everything: normal driving, the unjustified stop, the escalation. Pemberton's body camera captured his inability to articulate reasonable suspicion and his dismissal of Judge Harrington's credentials. Multiple independent witnesses corroborated the account. Judge Harrington's federal ID, vehicle registration, and driver's license proved her complete legitimacy. Pemberton had no legal basis for the stop, no traffic violation, no reasonable suspicion, no articulable facts justifying detention. Internal Affairs files documented the pattern: 23 similar complaints over 14 years. Most ignored every element of a H.R. 1983 claim was present. Fourth Amendment violation? Check. 14th Amendment violation? Check. Municipal liability for deliberate indifference? Check. Qualified immunity? Wouldn't apply given clear precedent against racial profiling and the complete absence of reasonable suspicion. The city's risk assessment was clear: go to trial and lose publicly with a jury verdict potentially 3 times higher, or settle now and implement reforms. The city settled 10 months later. $1.8 million paid to Judge Simone M. Harrington, one of the largest settlements in Austin history for racial profiling and the largest involving a federal judge. Officer Scott Pemberton was terminated 5 weeks after the incident. The union initially filed grievances, but withdrew them after reviewing the body camera footage, witness statements, and Judge Harrington's unassailable credentials. The termination letter was comprehensive. Officer Pemberton engaged in racial profiling, detaining a United States district judge based solely on race without reasonable suspicion or probable cause. He violated department policy on constitutional policing, bias-free policing, and proper detention procedures. He has demonstrated a pattern over 14 years of similar conduct involving 23 complaints, 19 targeting African American citizens, indicating this was not an isolated incident, but persistent failure to respect constitutional rights. His continued employment creates unacceptable liability for the city and violates the civil rights of citizens, particularly African American residents. The letter specifically cited 23 prior complaints showing the same racial profiling pattern, noting that progressive discipline had failed to modify behavior. Employment terminated immediately. No appeal rights due to severity of constitutional violations. Pemberton's name was entered into the National Decertification Index, preventing him from ever working in law enforcement again, anywhere in the United States. His 14-year law enforcement career ended permanently. No retirement in good standing, no pension enhancements, no law enforcement work anywhere. The union initially attempted to fight the termination, claiming due process violations. The city provided Pemberton's complete complaint file, all 23 incidents, all 19 involving black victims, all the training certificates that accomplished nothing, along with body camera footage showing the baseless stop and Judge Harrington's composed professional response that made Pemberton's racial profiling undeniable. Faced with a federal judge as the victim, video evidence, multiple witnesses, and a pattern no union representative could justify, they withdrew the appeal 3 weeks later with a terse statement about respecting the process. Pemberton released no public statement, Judge Simone Harrington testified before Austin City Council at a packed hearing 2 months after the incident. Dozens of supporters filled the chamber: attorneys, federal courthouse staff, civil rights activists, and community members who'd experienced similar profiling. The media documented every word. I'm a United States District Judge. I've dedicated 25 years to the law, as a prosecutor, as an attorney, as a federal judge. I've lived and worked in Austin for 15 years. I pay taxes here. I own property here. I preside over criminal and civil cases in the federal courthouse downtown. I know my rights. I know the Constitution because I interpret it daily. I teach constitutional law at UT. I know what unlawful stops look like because I've ruled on dozens of cases involving Fourth Amendment violations. And Officer Pemberton stopped me for driving while black. No traffic violation, no reasonable suspicion, just a black woman in a nice car. And he assumed I was a criminal, assumed the car was stolen, assumed I couldn't possibly be a federal judge. She paused, looking at each council member. I was humiliated in front of witnesses for committing no crime, except being African American in downtown Austin. I was detained illegally, had my credentials questioned, and was threatened with physical removal from my vehicle. All because Officer Pemberton couldn't imagine that a black woman could be a federal judge. 23 complaints over 14 years, 19 involving African Americans. That's not bad luck. That's not mistakes. That's a pattern. That's policy. That's the department tolerating racism. A pattern your department tolerated for 14 years because Officer Pemberton's supervisors valued his arrest numbers over the constitutional rights of the black people he profiled. She let the words settle. $1.8 million is what it cost to finally remove one officer who should have been fired after complaint 3. But money doesn't undo standing on West 6th Street being treated like a suspect by a cop who refused to believe my federal credentials. It doesn't erase the message that my Yale Law degree doesn't matter if my skin is black, that my position on the federal bench means nothing next to my race, that I'm never truly safe from racial profiling, no matter how high I rise. And it doesn't prevent the next officer with 23 complaints from doing the same thing to the next victim who can't fight back. This council needs to ask itself, why did it take 23 complaints? Why did it take a lawsuit? Why did it take a federal judge to finally get action? What happened to all the victims before me who couldn't hire civil rights attorneys, who didn't understand the law, who had no institutional support? Standing ovation from supporters. Several council members visibly uncomfortable, others nodding in agreement. Austin Police Department announced policy reforms 4 months later under pressure from the lawsuit, Judge Harrington's testimony, and sustained community demands. The chief acknowledged the need for change, admitted the system had failed, and committed to preventing future incidents. New measures included automatic supervisory review after 3 complaints with similar patterns within 36 months, mandatory termination proceedings after 4 sustained complaints involving racial profiling, real-time flagging system for officers with patterns of stops showing racial disparities, mandatory supervisor approval for any stop in affluent neighborhoods involving only suspicious person, calls without specific criminal activity, reported body camera footage, review of 100% of stops involving minority citizens in predominantly white areas, anti-racism training conducted by civil rights experts and community organizations, not police trainers, command staff accountability. Supervisors who ignore patterns face discipline up to termination. Community Oversight Board with subpoena power to review complaint patterns. Quarterly public reporting of stops by officer, race, location, and outcome. Integration of National Decertification Index checks to prevent hiring officers terminated for racial profiling elsewhere. The police union initially opposed several reforms, particularly command staff accountability and the 4 complaint termination rule, but relented under public pressure and couldn't defend the status quo after the federal judge incident. Why do departments wait for the 23rd complaint instead of acting on the 3rd? Why does it take a federal judge to implement common sense accountability? Comment your thoughts. Reforms to be fully implemented within 9 months, with quarterly progress reports. This wasn't about one Thursday evening. This wasn't about one traffic stop. This was about a department that tolerated Officer Scott Pemberton profiling black citizens for 14 years despite 23 documented complaints showing a clear pattern of racial bias. The pattern was obvious from Complaint 2. A black professional questioned in an upscale area. An African-American resident asked for proof in their own neighborhood. It was undeniable by Complaint 10. Same story, different victim, same bias, different day, same assumptions, different location. But Austin PD kept Pemberton on patrol, kept assigning him to affluent white neighborhoods, kept ignoring the warnings, kept accepting the excuses until he finally profiled someone with the knowledge, resources, and authority to force accountability. A United States District Judge. Judge Harrington paid the price, treated like a criminal on West 6th Street for driving her own car, detained without cause in downtown Austin for committing no violation, forced to prove her legitimacy, show her federal credentials, explain her position, while white drivers passed by without a second glance. The message delivered clearly: your Yale degree doesn't matter. Your federal judgeship doesn't matter. Your lifetime tenure doesn't matter as much as your race. Scott Pemberton's career is over. Terminated. Decertified. Barred from law enforcement permanently. That's consequence. The city paid $1.8 million. That's accountability. The department implemented reforms. That's progress. But those measures came after 14 years and 23 complaints. 14 years of black victims who didn't have a federal judgeship, legal expertise, or institutional support. 14 years of African American citizens who were profiled, harassed, detained, and had no recourse. No witnesses, no cameras, no resources, no one listening. How many others did Officer Pemberton stop in those 14 years? How many young black men detained without cause? How many African American women questioned about belonging? How many professionals humiliated who couldn't fight back? How many complaints never filed because victims knew nothing would change? The real question isn't why Pemberton did this. Racists will racist. The question is why the system let him keep doing it. Why do departments wait for Complaint 23 instead of acting on Complaint 3? Why do they recognize patterns after 19 similar incidents instead of stopping them after 5? Why do they prioritize protecting officers with documented racist patterns over protecting the black citizens those officers target? Why does it take a federal judge, someone with credentials white people respect, to finally get accountability? Why do settlements come from taxpayer money while officers who caused them face no financial consequences? Because if we don't fix the system that kept Scott Pemberton patrolling white neighborhoods for 14 years, if we don't address the culture that protected him despite the pattern, valued his arrest stats over civil rights, and ignored black victims until a federal judge fought back, then we're just waiting for the next officer with 23 complaints. The next victim profile, the next African American professional who gets profiled for the crime of being in the wrong neighborhood with the wrong skin color. This case represents thousands of others that never make news. Tens of thousands of black Americans profiled every year by officers who never face consequences. Millions of stops based on race, not crime. A system where being black is treated as reasonable suspicion. Comment if this should be federal law. Any officer with 4 similar complaints within 3 years faces automatic termination. No implicit bias training that doesn't work. No diversity workshops that change nothing. No progressive discipline that protects racism. Career over. Out of law enforcement permanently. 4 complaints. 4 similar incidents. 4 African Americans profiled in similar circumstances. That's not isolated incidents. That's a pattern. And patterns should end careers. And if you believe these stories matter, if you think 14 years of complaints should result in accountability before year 15, if you believe black judges deserve the same freedom from harassment that white drivers get automatically, then hit that subscribe button. We're exposing police misconduct and racial profiling. We're demanding real accountability and actual consequences. We're fighting for every black American who's been profiled and every victim who couldn't fight back. This isn't about one officer or one federal judge. It's about a system that gave Scott Pemberton 23 chances, 23 complaints, 19 black victims, 14 years, while black Americans don't even get the benefit of the doubt. It's about departments that protect officers with documented patterns of racial profiling, and the African American professionals and citizens who pay the price for that protection with their dignity, their safety, and their constitutional rights.